Justice delayed is justice denied. This is how we are familiar about. But then do we have right understanding that which institution is responsible for denial of justice? People think that it is the Indian judiciary which is responsible for denial of justice, and it has been also criticized that it is known for Tariq pe Tariq, that it is very infamous criticism of Indian judiciary. Even you know that Jolie LLB 1 and 2, the how Indian judiciary has been depicted, its image you can consider. India has 5 crore pending cases. In 2018, Niti Aayog had an estimate that how many years we would take to dispose pending cases with current pace, and it estimated 324 years. And in 2018, we did not have 5 crore cases. You know that. So you can imagine that today if we estimate 5 crore cases, how many years it can take. But that is not our subject today. Our subject is that we tell you right facts about which institution is especially responsible for pending cases in Indian judiciary and how we can solve them. Generally, people think that it is Indian judiciary which is responsible for pending cases, and they keep criticizing Indian judiciary. It is in this context you should know that our even economic advisor to government also went on criticizing Supreme Court and Indian judiciary, in particular, that it is an impediment in realization of our dream called 2047 developed India. So we have that kind of, let's say that dream to achieve, and we think that Indian judiciary is responsible for its, let's say that somehow non-achievement. Is it like that? So it is in that light we have been trying to tell you the right facts about Indian judiciary. Why? Because Indian judiciary is considered, I will tell you that, one of the most important organs you can say, and it is the guardian of the constitution. It is important to have faith in Indian judiciary and maintain its independence and efficiency if we want to have constitutional democracy. And that's why you should know that having right understanding is very important so that we can continue to have faith in our Indian judiciary. So let's see that what are those, let's say that status of pending cases and causes, consequences, which institution is mostly responsible for all these pending cases. That will be our main takeaway. Main focus of this talk today will be to highlight, tell you which institution is mostly responsible for pending cases in our judiciary. So let me give you the status that total pending cases we have 5 crore, of which in Supreme Court we have 88,000, in High Courts we have 63 lakh, in subordinate courts we have 4.6 crore cases, and in tribunals which are part of Indian judiciary over 10 lakh cases. So when you have such pending cases, you should know that they will have huge consequences, but that will focus a bit later. Let's talk about that. What are the causes due to which we have such huge number of pending cases? The causes can be considered, let's say that first cause is that's institutional capacity. Judiciary as an institution lacks capacity to dispose that number of cases with speed and efficiency. Now, what comes under that institutional capacity? It comes physical infrastructure, human infrastructure, and let's say that digitalization process you can say. So these things can be included in its institutional capacity. As far as physical infrastructure is concerned, you know that even 20% courts do not have proper toilet, even separate toilet for women, which will focus in another, let's say that talk when we will bring about gender representation in Indian judiciary. But that is how the fact you should know that 20% courts, let's say premises, they do not have separate toilet for women, and that way you can, let's say, evaluate yourself the physical infrastructure. Now comes the human infrastructure. If you take human infrastructure, then there are two types of things in that. Human infrastructure means staff, the support staff for judges, and then judges themselves. So you should know that ki support staff, there is no estimation that ki how much vacancies we have. But as far as judges are concerned, already in one video we have highlighted that you should know that ki vacancies generally remain. In case of Supreme Court, 1-2 judges. In case of High Courts, 30%. In case of subordinate courts, 20 to 30%. And let's say if you take tribunals, so they will also have 30 to 40% vacancies. And these vacancies are as per, the estimates in 1978 by Law Commission, which set the target that we should have 50 judges per million population. But we have 21 judges per million population. Then the question is that whether the institutional capacity, judiciary has institutional capacity to deliver the number of cases that it receives. Not at all. Then the question comes that which institution decides the institutional capacity of judiciary? So it is the government of India. It is the state government at the state level. And it is certainly, let's say, legislature. Means the first two organs, they decide what should be the institutional capacity of our Indian judiciary, because they give budgetary sanction. Budget is formulated by the government, approved by the legislature. Even if Supreme Court and High Courts, they have charged Consolidated Fund of India, means their funds are not voted in Parliament, but ultimately budgets estimates, the budget estimates are prepared by government and approved by Parliament. In fact, it is the government which knows how to govern. It is the government which has been elected by people to govern efficiently. Therefore, it is the government which is at first place supposed to provide adequate physical infrastructure, digital infrastructure, human infrastructure. And that's why let's say that blame should go to government rather than judiciary for backlog cases or delay in cases. This is one aspect you can consider. Then second is that that there is delay in appointment. Judges are not appointed even if the sanction strength we have, but they are not appointed timely basis. Let's say we have collegium system. You know how collegium system was born? First, second, third, fourth judges cases, that, and it was born. And collegium system has resulted into friction between government and judiciary. And because of that, there is often delay in appointment. You should know. And that result into increase in number of vacancies in High Courts and Supreme Court. This is one at, let's say that High Court and Supreme Court level. Let's take subordinate courts. Their appointments are done by state government in consultation with High Court. At the same time, we have a State Public Service Commission, and that State Public Service Commission is responsible for recruitment of, let's say that judges to subordinate courts. And then district judge is also appointed by state government in consultation with High Court. So the question is that at a state level, if you take subordinate judiciary, its infrastructure, human resource, and appointment, they are all under the state government control. So at a state level, if subordinate courts lack institutional capacity, so then it is the state government to be criticized. So then what we can say this, as so far we have talked about executive, institutional capacity. The main factor is that it is the institutional capacity that is not adequate enough to dispose cases efficiently, and that institutional capacity is determined by the government, not judiciaries. Simply because judiciary does not have budget, it cannot itself, let's say that create any institution, it cannot itself recruit staff, it cannot itself modernize its, let's say, infrastructure. That has to be done by the government, especially by Ministry of Law and Justice. So this is one aspect. Now let's take that next aspect of backlog cases, why it happens. So there are other factors. First, you can say government itself. Government is the biggest litigant in the court. Do you know this? That over 50% of the cases in courts come from the government. Government is one such party. So why government? Let's say that is source of number of litigants. This, and what are we doing to reduce those litigants? This is one factor. Next factor you can consider is certainly Supreme Court and High Courts. They are also responsible that they are very liberal in accepting cases related to special leave petition, SLP, and public interest litigation, PIL. Many times Supreme Court is criticized that it is a court of appeal rather than constitutional court. So their interventionist nature, judicial overreach, adventurism you can consider, is also responsible for aiding, let's say you can consider, in that means bringing addition in pending cases, because then you know that they will have so many cases coming through PIL and SLP. So judiciary is also responsible for that. Then let's say our legal system, you know that our legal system is, you know, it is a criminal justice system in India has collapsed. It is old, cumbersome, complex. Even if we have BNS, BNSS, BSM, it's new law that we have introduced, but they are just, let's say that top dressing you can consider, and therefore they may not address the entire aspect of our legal system, which is highly old and complex. You can learn by this fact that World Bank in 2020 highlighted that India had its position in contract enforcement 163 out of 190 countries. So contract enforcement, and in that contract enforcement, legal complexity is considered the main problem. So then other factors we can consider are police institution, you know that, investigating agency, you should know that. These are investigating agencies, police institution. They basically are the initiator of the criminal cases, you know that. Most of the criminal cases will be initiating from them. FIR, investigation, CBI, corruption, etc., etc. You can see this. And you know that how police as an institution is even worse than Indian judiciary, because then they will have their vacancies running to 30 and 40%. And that also according to the world standard. Like let's say in India, you know that we, according to United Nations, we should have 222 police per lakh people, but we have over 156 police per lakh people, and it may have a bit more increased. So, but we don't have 200 police per lakh people. And then police has its own, let's say, problems. I will give you 1-2 facts. By that you can yourself guess that police filed in case of Delhi riot 10,000 pages charge sheet. 10,000 pages charge sheet. You know that simply court cannot read it. Then Vyapam scam, if you take, in 2015, Vyapam scam surfaced. But after even 10 years, you should know, still charge sheet has not been filed. So if police has not filed charge sheet in Vyapam scam, so which institution we should criticize? Should we tell that it is judiciary which is responsible? So what we have counted so far, that what are the factors for pending cases? So first, poor institutional capacity, delay in appointment, vacancies. Then let's say Supreme Court being liberal, SLP and PIL cases you can consider, old and complex laws you can consider, police as an institution which lacks, let's say, efficiency you can consider, and a modern outlook you can consider. And the last factor we will tell is that ADR system. In our country, you should know that ADR, Alternative Dispute Redressal Mechanism, जिसको बोला जाता है, ADR is also not that effective. You should know that in Australia, US and Singapore, 80% cases, they don't go to the courts. they are adjudicated, that is called pre-litigation stage, and that is how they have a reduced burden on their judiciary. In our country, we can say that we have 50-60% or 60-70%, although that data is still not that empirical to tell you that yes, this is how we have number of disposal of cases at pre-litigation stage. Therefore, if you talk about judiciary as an institution, then ADR as an institution, so they basically lack institutional capacity. And they have lack of physical infrastructure, human resource, vacancies, judges, not timely appointed, and all these things are largely in the hand of government at first place, not judiciary. If Government of India will tell to Supreme Court to send proposals for appointment of judges, then do you think that the Supreme Court Collegium will not send names? And you should also know that when Supreme Court sends names, then government simply, let's say, does not respond. Even several times, Supreme Court Collegium or even benches have threatened to the government that they should act speedily. Otherwise, they will be forced to become harsh. So, the question is that we are not trying to put entire blame on the government. You can consider intentionally. Rather, you should know that in any system of governance, it is not judiciary that decides the system of governance. It is not the decision maker. It is the government that is the decision maker. It is the government that sets the tone and temper of governance of the country. Because budget is in the hand of the government. Reforms are in the hand of government. Judiciary at best can simply tell that these things should be done. But ultimately, its policy shape, budgetary support would be provided by the Government of India or the Government of a state. Therefore, if we think that it is the judiciary which is responsible for pending cases, I guess it will not be considered a right perspective. We need to change our perspective so that the pressure should be on the government to address these problems rather than just changing the goalpost, you can say, and putting the ball in this court or that court instead of solving the problem. Then let's talk that what are the consequences. You should know that when you have 5 crore cases pending, so consequences can be very, very serious, you can say, on economy. And those consequences you can consider in terms of, if you talk that in some, let's say that facts if you take, according to some reports, you will know that it is National Judicial Data Grid. So National Judicial Data Grid, according to its report, this 70% prisoners, let's say prisoners are under trials, you know that. 70% prisoners are under trials. And let's say according to, you can consider called World Bank report, these pending cases have impact on GDP. Their total value because of pending cases would be about 7.5% of our GDP. And each person who has a case in the court every year is spent, this is the average estimate, spend over 1 lakh, let's say that. Over 1 lakh is spent every year if any case is pending in the court. Then it can have its consequence on faith of people, you can say, development you can consider, governance you can consider. Means it will have its repercussion on everything. This economy, it will be considered as a drag because ease of doing business will be affected. Governance, because there can be paralysis you can consider. Because governments, they make policies, etc. and then adjudication takes its own time. As we have told that high courts and Supreme Court or judiciary per se takes over 4 to 5 years average time in disposal of cases, and tribunals take even 1 to 2 years. That is also not as speedy because they were supposed to give adjudication and final judgment within 1 year. So That can be the consequence on economy, on governance, on society, especially poor people. You know that they don't have means they do not get this kind of confidence that they should fight their case because of pending cases. It affects social justice also. And when justice delay, so this is how we popularly say, justice delayed is justice denied. So that is what we can consider in terms of consequence. What can be the solution for this when we talk that how we can address these backlog cases? Generally, we say that we need to conduct one audit, and that audit can be conducted by CAG or even Finance Commission. They should conduct audit to assess about the institutional capacity of judiciary and the gap in the infrastructure you can consider, pending cases, then how much expenses we need to bring, how much funding should be done, how much infrastructure, including human infrastructure, we need so that we can adjudicate these cases by making it as a mission mode approach. Means we have to take one-time decision to dispose all these cases which can be assessed either by CAG or by Finance Commission. This. Second, that we need to have, improvement in recruitment. There should be regular recruitments to improve infrastructure, especially support staff in Indian judiciary. And then it's physical infrastructure, physical plus digital infrastructure, that should be improved, for which there has been suggestion that we can create a National Judicial Infrastructure Authority, or we generally consider as National Judicial Corporation we can consider. Either you adopt a corporation or authority which will be responsible for monitoring, assessing, and improving judicial infrastructure in the country. And then we can introduce All India Judicial Service so that it can address appointment and vacancies related problems in high courts and Supreme Court, we can say. And at the same time, we can constitute National Tribunal Commission for empowering tribunals in our country. So there can be several such suggestions, we can say. Government is already going, it is applying artificial intelligence and it is digitalizing Indian judiciary. So there is application of, AI and digitalization, and it has gone through 3 phases of digitalization. So digitalization has been very aggressive, we can say. Many such cases are being heard online. Virtual hearing is there. That can be considered as good development. But you should know that digitalization cannot address all these problems, are human problems. And therefore, let's say that if we need to address backlog cases, we have to address vacancies, we have to improve number of judges per lakh people or per million people, as per what Law Commission was talking about. And at the same time, we need to work out on the causes of generation of cases. You should know, think over this. Why there are generation of number of cases, so many cases are being generated. Why? So why we do not reduce the generation of cases? And you know that how cases are generated. Today, anything, related to administration, government, anything, if government fails, then people go to judiciary. It means if government does not fail at first place, then people will not go to judiciary. Then its precious time will not be wasted. Take the example of a special intensive revision in Bihar. Why Election Commission at first place did not take all the precautions which were told by Supreme Court? In fact, Election Commission of India has better wisdom than Supreme Court in terms of conducting free and fair elections, as it has institutional memory. But it is being told by Supreme Court that what to do, what not to do, and that is how it is taking Supreme Court precious time. And similarly, you can say that there can be so many cases where the first 2 organs, they fail, and then those cases go to judiciary. Therefore, the pressure should be on the first 2 organs to become more proactive And if they would become more proactive, judiciary role will be just like an umpire, just playing the role of arbitrator between government and people, and its role can be very, very limited. Therefore, this is how we can talk about pending cases, cause and consequences. Hope that it will give you right understanding about which institution is exactly responsible for justice delayed is justice denied.